Good afternoon. Thank you all for joining us. My name is Jay Fortune. I am the office manager here at Standpoint. My role today is going to help facilitate the webinar. So if you have any questions during the presentation, please type your question in either the chat box or the Q&A tab, and I can pass the question along to our presenters today. Most of you probably know a little bit about our organization, but for those who are going to end up listening to this later on YouTube, Standpoint is a statewide organization. We're a team of attorneys and advocates working to assist individuals who have experienced domestic violence, sexual violence, and trafficking when it includes domestic or sexual violence. We also provide assistance to system professionals who work with survivors. We do this by facilitating trainings or answering calls to our action line. Examples of the trainings we do are our annual new laws throughout the state of Minnesota, or like this year, virtual, monthly webinars for advocates, and other trainings by request. Our action line is answered Monday through Friday from 9 to 4 p.m. It's through our action line that our attorneys provide legal advice to survivors, and our advocates connect callers with resources, safety plan, listen, and help callers identify possible options and next steps. This webinar is being recorded, and you can check it out on Standpoint's YouTube page afterwards. The link will also be emailed out to our legal advocates listserv after the webinar. For today's presentation, if you'll notice, I put in the chat box the link to the PowerPoint and materials, if that's easier for you to kind of follow along. Now I'm going to introduce our presenters today. We have Amy Isenor joined the team at Standpoint in April of 2018. Amy comes to us with experience in child protection, civil commitments and guardianships, family law, including orders for protection, dissolution and custody, harassment restraining orders, and representing victims of domestic and sexual violence. Having worked as a prosecuting attorney and in representing respondents in civil matters, Amy's nearly 20 years of legal experience and more than that in the social justice field have prepared her to advise attorneys, advocates, and victims with their legal needs. And Amy has also received numerous awards for her service to victim survivors. Beth is newer to Standpoint. We're really excited to have Beth join our team. So Beth Assell joined our team in October. She graduated from law school at Hamline University, and directly after graduation, clerked in juvenile court in Hennepin County. Most recently, she worked as a staff attorney at Central Minnesota Legal Services for 6 years. At CMLS, Beth provided direct representation and legal advice in the fields of family law, orders for protection, harassment restraining orders, and criminal expungement. She also partnered with the Domestic Abuse Service Center to represent victims of sexual and domestic violence and strengthen the capacity of advocates working in those fields. Beth previously worked as a full-time volunteer with Lutheran Volunteer Corps and AmeriCorps and brings to Standpoint a lifelong passion for advocacy and helping others. So I'm going to pass off to Beth and Amy.
Good afternoon, y'all. Amy Isenor from Standpoint. Thank you for joining us. We're so happy to have you here. Typically, for the past 3 years, when you've called Standpoint for family law issues, you've probably been directed to me if you had legal questions. And now that Beth has joined our team, she's the primary person that you'll be talking to for family law. And I'll still be handling a lot of other areas of law and then back up if Beth's not available. So I'm super excited to have Beth's expertise on the team. It's taken a lot of pressure off of me. And I'm super excited to do this presentation with her today because she has lots of more recent courtroom experience and working in this field. So we're going to get started here. Beth, do you have anything to add first?
I don't think anything to add. As Jay said, I'm Beth Assell, one of the newer attorneys at Standpoint, and thanks everyone for coming.
I have to move us because we are blocking what I can see. Okay, so if you're looking for the basics, we do have 2 prior webinars on family law. They are on Standpoint's YouTube channel, which you can go to and look if you're looking for more basics 101, what are kind of definitions, what is physical custody, what is legal custody, how does it work, what does the court look at, best interest standards. A lot of those 101 type of things are in the Family Law Advocacy 101. Makes sense that it's there. And we're not going to cover that today. We're kind of going to try to take a real deeper dive into some issues that we're seeing as a trend lately. Also, if you want a reminder on the various roles in family court, parenting time expediters, child support officers, guardian ad litems, parenting time consultants, custody and parenting time evaluators, what are all their roles and what do they do? What authority do they have, and how can your clients interact with them? That is also on our YouTube channel. It's called Who is Who in Family Court. So if you want to go back and do some refreshers on those issues, we just wanted to point out that they're there, and we're probably not going to touch on that much today. Today, we really want to take a deeper dive into family law and look at some trending issues that we've been seeing. So we will talk about parenting time establishment and what are some really important things that victim survivors need to consider when they're setting a parenting time schedule. Initially, when they set it, when they determine what it's going to look like moving forward. Typically done either for non-married parents or when the couples separate initially. Parenting time modification is, we'll talk about when can you modify a current order, what kind of best motion is it to file at that time, what will best meet your needs, and can you bring a motion while the case is still pending before you have your establishment order. We'll talk a little bit about third-party custody and can a non-parent file for custody and how do they do that? What are the pros and cons of that, and why might it be a really good or really bad idea for our clients? And then special considerations for unmarried mothers, people who were single at the time of the birth of the child and thus have sole custody. Lots of questions that we get around this are, can I move out of the state with my child? What do I do if the opposing party has the child and won't return them? This has been an issue throughout all of the ages, but with COVID, it's becoming even greater of an issue. Perpetrators are using COVID as an excuse to not bring the children back, and how do we deal with that, and what options do victims have in that? And finally, can I get a passport for my child? I'm an unmarried person. I'm the only one on the birth certificate. Maybe he's on the birth certificate, but I have custody. What do we do in those situations? So I prefer these webinars and presentations to be exactly what y'all need and are looking for. So Jay and Beth will be monitoring the chat box and the question and answer box. So if you have any questions as we're going along, feel free to pop them in and I will answer them orally so that they're on the recording for people viewing this webinar on YouTube later. So when we talk about establishment of parenting time, there's several different places where this can happen. If a person is unmarried, it is completely up to the person with sole custody. The mom has sole physical and legal custody. But when they do establish it later, moving forward, the places that you can do that are in a dissolution or divorce proceeding. As part of the divorce, you establish what custody and parenting time is going to look like. You can do it in a custody and parenting time action, including an action for third-party custody, which we'll talk about later. So if a couple who's not been married, either parent files for custody or parenting time, it can be established through that proceeding. That's typically what they're for. And it can also be established in an order for protection. And as we move along and we get farther into the details of this, we will talk in depth about the pros and cons of establishing parenting time or custody through the order for protection process. And also about when we just do it without court involvement, if we establish parenting time on a voluntary basis, how may or may not that affect the future of the court process when we do seek to establish it formally. So one thing to consider, and I acknowledge as an attorney representing people in these cases, I often forgot to think about this. And at CMLS, it's right on their intake portion. They're very good about catching this, but I think we often don't recognize or think about, talk with our clients about convictions that can affect custody. And so if a client or an opposing party has one of the following convictions and some other things happen that we'll talk about in a minute, the court must consider it and take special care when establishing custody and parenting time. So if a parent is convicted of murder or manslaughter in any degree, assault in any degree, 5th degree assault, criminal sexual conduct in any degree, various crimes that harm children, including solicitation for prostitution, malicious punishment, neglect, when there are criminal convictions for that, terroristic threats or threats of violence, as it's now called, incest, where there's inappropriate sexual contact with a family member, felony level harassment, not misdemeanor gross harassment, but felony harassment, which is also with our stalking statute, and domestic abuse by strangulation. So there's several others that don't really pertain as much to domestic violence and sexual violence, but these are things that if the other party, particularly when we're working with our victim survivors, is convicted of one of these things, the court must look at that and consider, like, that kind of creates a presumption, like, dude, you did something bad. If the conviction was in the past 5 years, if the person is currently incarcerated, on probation, or under supervised release for the offense. So I said there were certain offenses and then some other things had to be true. These also must be true. So it was the conviction was in the last 5 years, they're still on probation or incarcerated, or the victim was a household member defined by our OFP statute. So 518B.01, we have the specific definitions of what a family member is, a family or household member. And so in other statutes, there's other definitions, but when we're looking at when the conviction applies, so we're looking at not necessarily our household right now. If I have a new partner and now I'm separating and establishing custody for my child, if they have had previous convictions for these things with a previous partner or child, it will be included in the considerations the court makes for my child. If the person was a victim, if the victim of the crime, whenever that took place, was a household member. So when we're looking at the family or household member victim status, there's not a time requirement for that. If they perpetrated sexual assault on a child 25 years ago, you now have a child, that's going to be considered because it was a family or household member. So then what? What if the court finds that they are convicted of one of those things and one of those 3 factors we just talked about happens? So the court is prohibited. They cannot grant custody or parenting time to that offender unless the court finds that custody or parenting time is in the best interest of the child. So there's a presumption that there will not be parenting time or custody to that convicted person unless the court makes specific findings of why, despite this crime and the risk it could potentially pose, I'm still finding it's in the best interest for whatever reasons that they find that. Could be rehabilitation, could be circumstances, could be lots of different things where it's in the best interest of this child. I also believe that in certain kinds of convictions, the court might find differently for siblings, which we don't typically like. We want siblings to have the same custody and parenting time as each other with their parents, but depending on the crime, there might be different considerations for certain children. So when this happens, the standard of proof becomes clear and convincing evidence if the victim was a household or family member. So not a high bar that we have to meet to prove that. If there's a convicted parent, a guardian ad litem must be appointed. That's a statutory requirement. We know that with funding and other issues happening, that's not always happening in every jurisdiction. Guardian ad litems are not being appointed, but the client can definitely ask for one if they want that or think it would be helpful. As advocates and attorneys, we always need to advise our clients about the pros and cons of all the decisions that they're making and educate them about that so they can make the best decision for their family, obviously. We already talked about that it doesn't matter how old the conviction was. If it was 25 years ago, but against a family or household member, it's going to be considered and be an important part of this consideration for the court. And it's up to the parties to bring this to the attention of the court. A lot of times I've had callers or clients tell me, the court should have known I have an OFP, and in the OFP I said blah, I said all the details, I gave the file number. The court's not going to go look at your OFP when they're looking at your custody and parenting time motion or petition. The court's not going to go independently and search your other parties, the other parent's name, and see if there's convictions. It's our responsibility as attorneys or the clients, if they're pro se, to provide this information to the court. They are not going to do their own investigation. They're not going to know this. Even when they're in the same, like in small jurisdictions where it's one judge hearing all the cases, if the judge heard the criminal case, the judge heard the child protection case, the judge heard the order for protection case and the violation of that, and now they're hearing your parenting or custody or divorce case, they're hearing only your parenting, custody, and divorce case. All these other things might influence them and affect their opinion, but they cannot consider this unless you present it as evidence in your custody case. So again, it's our responsibility to not assume the judge knows things. It's also the judge's responsibility not to take into consideration prior biases they might have from those things if there's not evidence provided in this case for them to take into consideration. So we always need to remember that it's our job to educate the court and present it even if we know they know. So parenting time presumptions. There's a rebuttable presumption that a parent is entitled to receive a minimum of 25% of the parenting time for their children. So a rebuttable presumption is what we assume is going to happen. What is going to happen unless. So the presumption is that the parent will get 25% of the parenting time. But if you provide evidence of why that's not in the best interest of the children, that presumption can be rebutted. It can be, evidence can be shown to show that that assumption should not happen. That typical presumption of what the court is typically or regularly going to do at a minimum is rebutted because of the domestic violence or the child abuse or the harm that could come to that child through that. That's rebuttable presumption is used a lot in family law. We've talked about it several times in new laws recently, but remembering that can be sometimes hard. It took me a couple of trips through the experience to like figure out, okay, this is what it means. So please call us if you have questions about that. What 25% of parenting time usually looks like at a minimum is kind of the old school every other weekend and one night a week is 25% of the month. Is that right, Beth? That's, yeah.
That sounds like a pretty typical 25% schedule, yeah.
Yeah. And when there's not child abuse or domestic violence or sexual violence, it's often more than that. But there's a large push that you better at least give me that much, judge, because I'm entitled. But it's not an entitlement. It's a presumption.
Right.
And so this 25% is calculated by overnights or substantial time during the day, typically over the year. So over 365 days, how many overnights do you have? Then that changed recently. It used to be days, and now it's overnight time. So perpetrators for child support purposes want more time so that they don't have to pay, because now child support is also being determined by overnights. And so 50-50 is really being pushed for because they don't want to spend their money on their kids, I guess. So in the absence of other evidence, without us providing other reasons why, they'll get at least 25%. But it is not an entitlement when they come in and they say, you have to give me at least 25%. When attorneys say that to our pro se clients or to us, we have to remember that it is not an entitlement, that it's something that we can push against, and if we provide evidence to the contrary, that we can prevent that from happening when we need to protect families. So what else does the court consider when they're establishing parenting time and custody? So in our 101 family law on our YouTube channel, we talked about the best interest factors. There are 12 of them, and they're listed out in Minnesota Statute 518.17, which is on the screen here. You can go look at it for your reference. I oftentimes will email the list to my callers on the phone and say, this is what the judge is going to be looking at. Right. Make a graph. And I actually have a document that I can send to them. So it's like a 3-column document. On one side is the 12 best interest factors. Then we have, so when you look at mom, when you're looking at you, victim, survivor, client, how do you meet these or how do you not meet these needs of your child? How does your partner or their other parent meet or not meet the needs of the child? And go down the guide. So person's not been involved till the child was 6, suddenly they want 50-50 custody. When you look at the best interest standard and you can demonstrate that they haven't bathed the child, they've never taken them to the doctor, they don't know what school they go to, they don't know what medicine they're on, they're not involved in the child's life, they took them maybe for Christmas 3 years ago. Like, all of that stuff is super important unless you've been divorced and are now separating, and it's always been joint parenting and joint everything. The judge is going to consider all of that. And so writing that chart can be really helpful. Can also help to really place into your testimony and into the evidence you want to provide to a court, like fitting things into categories, kind of. Sometimes we look at things as a narrative and clients will tell us about, they don't even do this and this abuse happened and they did this to me in front of the child. And when you put it into the areas, it can really help to keep their brain focused as they're talking about it. And also to direct the judge, like part of best interest factor number 4 is, I don't know, because I don't have them memorized, but, and the OFP was based on this. And so this means that it is not in my child's best interest. They do not meet their mental health needs. They refuse to take them to therapy. They continue to mentally abuse them, whatever. So I'm not going to go through them again. We're not going to go into a deep dive into that because it is on the prior webinar. But remembering that and giving pro se clients and our clients an opportunity to kind of focus their brain that way can be really helpful for them in preparing.
And it would be like, oh, sorry, not only for court and trials, but if your client's working with like a custody evaluator or they're preparing for like a mediation, early neutral evaluation, those are the exact same factors that those evaluators are going to be considering when they're making their recommendations. So I think it's important to look at those factors even earlier on in the process, just to kind of, like you said, Amy, kind of orient their thoughts on what's relevant and why it's relevant, so they know how to best present their case.
Mm-hmm. Absolutely, thanks.
Yeah.
We put a link in here. I don't know if it's a live link or if you have to copy and paste that into your browser, but there's a child-focused parenting guide that talks a lot about looking less at the parents and more at the child. What does the child need and how can we meet that need through how we establish what their life looks like? Not my life, I get to have my kid 50% of the time, but their life, where are they comfortable and established and that kind of a thing. And it includes different considerations for different ages. I haven't looked at this for years, but when I looked at it again, like, it is a super helpful resource and can be helpful in helping parents to look at what's kind of reasonable. Like, what's reasonable to them is that I should have my kid. And maybe what's reasonable for a 3-month-old is different than what's reasonable for a 3-year-old or a school-age child or a teenager who's going to make their own choices. And so this guide can be super helpful resource as well.
Yeah, exactly. If you feel like the other party's making kind of a demand for parenting time that doesn't really make sense with your child's age, like let's say a brand new nursing child, I think, at least I found it helpful in court to point to this guide and what's kind of helping a judge see that it's not just my opinion, but it's science, what's good for kids of certain ages, and that can be really helpful.
Yeah. So we have talked about this over and over in lots of trainings that we've done with y'all. How establishing custody or parenting time in an order for protection is something we really want to caution our clients about, particularly if the clients are not married, have never been married, and mom has sole custody. Filing an order for protection on behalf of the child requires that the child actually have been a direct victim of the domestic or sexual violence. They cannot have watched mom be a victim. They can't have been in the room. They can't, I mean, all those things are important and you want to present them in your OFP, but they are not a legal basis for the child to become a protected person or to get the order for protection on behalf of the child. However, the whole second half of the petition, where you're asking for the different kinds of relief, does include a part about parenting time and custody. And when a parent is the sole parent, they're not married, there's no paternity established, there's no custody or parenting time orders previously, we're just starting with an OFP. We want to be cautious about including the children or including specifications for parenting time or custody, because you might be giving them something they don't have. And when you're asking for protection because something bad happened, you don't want to volunteer your kids to be with them if they're not safe. So not asking for any relief regarding the children might be a safer option. Or if it's really important to you that their other parent continue to be actively involved in their life, you can do that in an order for protection and establish boundaries around that. You can ask for it to be supervised. You can ask for it to be exchanges at a safe location. You can ask for no contact with the party except that they can contact you about emergencies regarding the kids while the kids are with them. And so you can address it and establish it through an order for protection. Oftentimes, I advise clients to not even file the order for protection or ask for the relief, because doing so does provide an opportunity for the respondent to then ask for the hearing and then ask for relief in that second half, even though you didn't petition for it. So again, you're opening a door for them to seek parenting time, which they may not already have a right to. So sometimes filing a harassment restraining order might be a better option in that situation, even though the conduct rises to the level of an order for protection. And so it's always important to talk through those risks, pros and cons with the client when we're looking at establishing custody or parenting time through an order for protection. So I have talked a lot for half an hour now. I love animals and babies. I do not like cats, so you're not going to get a Raina presentation with memes of cats. You're just going to get cute puppies and animals asking for questions. So now's the time we're going to move on to modification of parenting time and custody, but we wanted to create a space for any questions that pop up. Beth or Jay, is there anything in the chat boxes or question and answer, please?
I don't see any.
Okay, we'll move on then. And if there are, hop in.
Can I don't have a question, but I have a correction corner for something I caught that I put incorrectly on our slide.
Okay.
Going back to what I call the burden shifting crimes, it's the very first slide one of the first slides that Amy talked about when we listed. Go forward one, Jay. There, right there. When I say assault any degree, obviously what I meant was assault 1, 2, or 3. I apologize. I should have been more clear about that, but it's only first, second, or third degree assault. That would put the other parent into, again, what we call these burden shifting crimes. if they are convicted of 5th degree assault, I think that's still a very relevant factor, especially when you have to take domestic abuse into account, but it won't be part of the statute.
So it'll be considered and certainly address it and talk about it, but it doesn't change the burden that the judge can't give them custody.
Right.
I did have one other question. On this slide, the standard of proof becomes clear and convincing evidence.
Yeah.
To prove the crime, or isn't, I'm confused on the burden there. Can you?
Okay. So what the statute says is that if the person seeking this custody has one of these statutes, the burden of proof shifts to them to prove that custody or parenting time is in the best interest of the kids at all. And so what the statute's saying is that if they're convicted of one of these crimes and the victim of their crime is a family or household member, then their burden, the person seeking parenting time to get parenting time, becomes clear and convincing evidence, so even higher.
Got it.
I would say even harder for them to get that custody or parenting time.
It's not just a preponderance where they just have to a little bit. It's like, okay, judge, it's not a big deal. They have to like show it. Got it. Exactly. I said that wrong earlier, so I apologize. Thank you so much for that clarification.
You're welcome. Okay, so motions. So when we talk about motions, what you're looking at is that you would have some kind of existing family court case, right? It can be one that's completed, your client has a final order, or one that's pending that they're in the middle of, like a divorce or a custody case usually. So as advocates working in this field likely know, and they've had clients go through it, family court cases can take a very long time. They are not quick proceedings. They're not meant to be quick emergency proceedings like orders for protection are. I think a lot of people have questions about how long is a family court case going to take. I always give the answer, it depends. The annoying answer, it depends. But as an example, there was one judicial officer in Hennepin County who would always say at his very first hearing, okay, my goal is to wrap this case up in a year. That was his goal, a year. So I think you can look at that's going to be kind of a typical timeline. So if your client's in a position, and this might be more common in high conflict or high need cases, where they can't wait a year for a final order. They need something in place. That's a situation where your client can consider filing what's known as a temporary motion. And so they're looking for some kind of court-ordered relief that's enforceable to be in place while they're going through the family court case. It might take some of the burden off of them while waiting for that final order. So some examples of what the court can rule on a temporary basis: temporary custody and parenting time, temporary financial relief. So an example would be is if you're in the middle of a divorce that sounds like it's going to take a while and your client's cut off from resources, they can bring a motion in that case for temporary child support to get that money rolling in while the case is pending. They can ask for temporary use and possession of the home and other property. They can ask the court to not only award things, but also to stop the other party from doing something. Some examples I have here are misusing assets or removing a child from the jurisdiction. So like stopping the other party from taking a child out of state. And there's also, in the statute that governs temporary motions, there's also what's called a catch-all, or what I'm referring to as a catch-all provision. Basically, it says the court can order these specific things or anything that will facilitate the just and speedy disposition of the proceeding or will protect from physical or emotional harm. So that gives your clients a little bit of leeway to ask for things that they think would be helpful on a temporary basis if they can kind of fit it into that catch-all provision. So one example of a temporary motion I've brought that brought a lot of relief to the client while a divorce was pending is not only temporary child support, but also these parties had exactly one vehicle, and she had an order for protection, needed to get to work, had all 3 kids, and he would not give up the car. So we got temporary child support, temporary use of the vehicle, and on a temporary basis, he had to pay the car insurance. So I know that was something that gave her a lot of relief and well, well, the divorce stretches on forever, she at least knows that she has money coming in, she has a car, you know, she can get through it.
Beth, can I ask a timing question on that?
Yeah.
So the first hearing is the ICMC, the Initial Case Management Conference.
Right.
And the rules state that you can't file a motion prior to that hearing.
That's right.
And so this is another step that the clients have to take after the ICMC to file a motion to ask for these things?
Yeah,
Exactly.
Okay. Exactly. You'll find that at the ICMC, so your very first hearing, Initial Case Management Conference, ICMC for short, which is the very first hearing in any divorce or custody case, that the court is not going to rule on any contested issues, and so they're not going to be hearing any motions. They'll only rule on things if parties have a full agreement. I find that what I would do is if I knew it was a case that I wanted to bring a temporary motion, either because my client needed some kind of temporary parenting time, like let's say I was representing a father who didn't have any custodial rights, or like the example I used, temporary child support, I would make sure at that first ICMC to ask if we could get a date on the calendar for that temporary motion, just to get that moving. Sometimes if a party agrees to some kind of mediation, like a social early neutral evaluation, they might even make them wait until that's over. So that's also something to keep in mind too. And then when it comes to these temporary motions, just keep in mind the court can't deny parenting time or exclude a party from a house unless it finds that physical or emotional harm would occur. So if you're asking you're asking to deny parenting time or remove someone from a house, you're going to have to prove that too, that there's going to be physical or emotional harm if that doesn't happen. Okay, I'm ready for the next slide. Okay, next slide is about what we're calling post-decree motions to modify. In post-decree, we're just talking about, so not if the case is pending, but if your clients are in a position where they've already been through a family court case, again, like a divorce or a custody case, and they have a final order. And then something about that order they don't like, so they want to bring a motion, which is the official request to the court to change something about the order. And so the advice that I would make sure to give your clients is that before they consider a motion, they should always check their divorce decree or their custody order carefully. It might seem pretty obvious, but I do find that, especially if it's a while ago that they've had their case, parties may not have a copy of that order handy. And if they don't, they might have only kind of a vague notion of what was ordered and what's in there. And so they might find a couple of things that they have to address before they bring a motion, or they might even find that there's already a method in that order to resolve their issue. So a big thing to check for is what's called a mediation clause. I think in a lot of counties, these are very common, that when you have a final order, the judge will require or strongly encourage that the parties put a clause in their final order saying that before they come back to court, it's usually limited to like custody parenting time issues, but before they come back to court on custody or parenting time issues, that they have to attempt mediation first. Some clauses may be more specific and have exceptions, say like if it's an emergency issue or an issue of contempt, like the other party's not following it, so I need to find them in contempt, that mediation clause doesn't apply. But if there is a mediation clause and parties just go back to court first, asking for relief without trying mediation, I think you will see that courts will deny that motion because the client hasn't followed the rules of what their order lays out. And that's just a frustrating waste of time and resources for everyone, but especially your client if they went through all the work of bringing a motion. If they do have this clause before filing their motion, let's say they go to mediation and it's not successful, or the other party won't respond to them or refuses mediation, which does happen. If your client has at least tried, they should file what's called a certificate of settlement efforts. That is a link. It's not a live link, but you can follow the hyperlink by highlighting it. And a certificate of settlement efforts is just a court form where you have to check a box saying that you've tried to settle the case before coming back to court. There's specifically a box saying, you know, we're ordered to attempt mediation. I did that. You file that, you're good to go. Even if the even if your client's order doesn't have a mediation clause, it's still recommend that you file this form. It's required by the rules, and you can just explain why you shouldn't have to attempt mediation. Okay, one type of motion, post-decree motion, is called a motion to modify custody. So just as a reminder, if your clients had a custody or divorce case that's involved kids, the court will have decided custody, physical custody and legal custody. It is not uncommon for us to hear from folks who want to change those labels, who have, I would say it's more common for them to have agreed to joint legal, joint physical, and they want to change those custody labels to sole. It is possible, but it's a very strict legal standard. The forms for doing that are available online. We have the link there. So this is just kind of a couple things to keep in mind, is that first, with the motion to modify custody, the timing is key. If the order that they want to change is less than a year old, they can't file to modify custody unless they can show that there's some kind of danger or that the other parent is really interfering with their parenting time. And if they've requested a change of custody and it's been denied, they can't try again for 2 years. When you do file to modify custody, you have to show that there's been some kind of change in circumstances is the first thing the court looks for. And the change in circumstances of the parties has to be significant, and it has to be changes since the original custody order was in effect. It can't be a continuation of ongoing problems. Basically, if the other party is doing the same kind of thing, same kind of stuff they were doing before, but now it's just they can't stand it anymore, that's probably not going to be seen as a change of circumstances. In addition, they have to show one of these things. The most common thing is that they can show that there's some kind of endangerment. So the child's present environment endangers their physical or emotional health. They can show that there's an agreement to modify custody, not common. They can show what's called integration, also not common in my experience, but basically it's the other parent has basically let you assume custody. They've just, for whatever reason, they've given up and said you can have custody through their actions. That can be integration. Or if the person bringing the motion can show that there's some kind of persistent denial or interference with their parenting time, that can be a basis too. And you also have to show that a modification of the custody labels is in the best interest of the child. So the court is gonna, even if you show all these things, a change in circumstances or that there's some kind of endangerment, the court also is gonna take in mind that maybe a change in environment is also, can be traumatic to the child, and that's a factor too. So the modification of custody is technically a two-step process. At the first step, the court is supposed to do what's called find a prima facie case. I won't go into that much, but basically they have to look at your client's motion to modify custody and say, okay, just based on what I'm reading here, if I assume everything's true, are they alleging enough for this to be a motion, to meet this standard? If not, they have to deny the motion. If yes, they are supposed to set an evidentiary hearing, like a trial. You might also find that with a motion to modify custody, because people are alleging endangerment or a significant interference with parenting time, that a court might appoint a guardian, set it for a custody evaluation. It can be a very long process for clients to modify custody. It is not an easy motion to bring. The next another type of post-decree motion that might be appropriate in many more circumstances that maybe clients don't think of right away is called a motion for parenting time assistance. So a reminder here that parenting time is a different concept than custody. I feel like clients kind of interchange a lot. They talk about they want more custody, or the other parent wants more custody. And custody is the legal or physical. That's either sole or joint. Parenting time runs the spectrum. Parenting time is the actual time that a parent spends with the child, regardless of what those custody labels say. With a motion for parenting time assistance, I think of it as a way that you can, especially because the motion to modify custody, that's so hard to meet and it's such a long and difficult process. In my mind, this type of motion is a way that you can be creative and help your client problem solve. So the court can award compensatory time. So if your client has missed a lot of parenting time because the other parent has withheld, they can ask for that time to be made up. You can change the schedule. You can change supervised to unsupervised, or if the court order just says something terrible and unhelpful, like you get a reasonable schedule, you can ask for it to say an actual schedule that they can count on and enforce. You can change the visits to a supervised location. You can change the actual transfers to an exchange center if your client's not feeling safe with how they're exchanging the child. You can change transportation rules about who's driving, and you can request civil penalties. That would be, for example, there's ways for the court to try and impose penalties if one parent's withholding parenting time would be an example. So there's a lot of ways where I think this type of motion can be helpful. I think one example from my practice is we had another parent. In that case, it was a dad who really fought for parenting time, but then when it came down to it, he was not exercising it. It was creating a lot of issues for my client because she was showing up to exchanges week after week and he wouldn't come. And she didn't want to be in the position of not showing up because then it may look like she's withholding. So we brought a motion for parenting time assistance, asking the court to order that if dad missed a certain amount of times, he would automatically forfeit his parenting time and giving him a certain amount of time to show up. And then she kind of has that court order to back her up when she says if he's not coming, she's not going to allow parenting time or keep coming to the exchanges. If your client was like in a hard place in her life during her custody case or her divorce and her parenting time was reserved, for example, she wasn't giving any parenting time, this would be the type of motion for her to bring to come back to the court and say that she wants an actual schedule and not for it just to say that that her parenting time is reserved. Okay, ready for the next one. So big question is what type of motion to bring. So first I would say before your client files any type of motion, again, help them look at their order. If they don't have a copy, you can buy a copy from any courthouse, or you can call Standpoint and we can help you look it up. And you should always get advice from a competent family law attorney. But basically just some questions they should be asking themselves is, an example is, will a modification of the custody labels actually help them meet their goals? I think what we hear a lot is just that clients are so frustrated with their situation and they're so unhappy with the other parent and they just want to modify custody. You know, that's what they have in their head. I want to modify custody. I want custody. And just changing those labels may not be enough. They might find that there's more of a creative solution that can be addressed through a parenting time assistance motion. Even if they do maybe meet the standard to modify custody, is your client ready for a lengthy court process? Have they met the timing requirements that we went over before? Do they have all the evidence they need at this time to bring that motion and succeed? Because keep in mind that if they bring the motion and it's denied, they're barred from bringing it again for 2 years. So they should make sure that they're completely prepared before bringing that motion. Okay, ready for the next one? So before your client signs any type of agreement, so we know most family law cases, like divorce or custody, they do end up settling. Most cases don't go to trial. Most cases do settle either at a mediation or outside of mediation. So your clients may end up signing an agreement or putting some kind of agreement on the record before the judge, you know, affirming to the judge that they've reached an agreement with the other party and here's what they've agreed to do in terms of custody and parenting time for their kids. A big thing to warn clients, custody labels can be very hard to change. Many clients might agree to custody labels or a parenting time schedule without understanding the long-term implications that we just talked about. Mainly that if they agree to joint legal, joint physical, chances are they're going to be stuck with those labels for a very long time. Similarly, if they agree to the other parent having a lot of parenting time, including like an equal split, very good chance that they're going to be stuck with that schedule for a long time. So I have just some ideas here for creative solutions that I've found in the past. If your client is in a position where they think that they're going to agree to joint custody, especially joint legal custody, but they're maybe wanting to protect themselves a little bit more. Just some ideas is there's a different standard for modification of custody, though. So putting aside everything we talked about before, clients and the other party, if they both agree, they can put in their order what's called a best interest standard for modification. It basically means that, okay, we understand that the usual standard is endangerment, but we're saying that if we want to modify custody in the future, either one of us, we just need to show the court that it's in the best interest of the child. Sometimes that can be a safer thing for your client if they want to try joint custody for now, but they want it to be a little easier to bring a motion in the future. If it's just not working out, they can agree to what's called a best interest standard. With legal custody, again, legal custody is, as you know from our 101, it's the major decision-making authority for the child. So who's going to make decisions about their religious upbringing, educational, medical. You can give one parent what's called tiebreaker authority. Basically, like, we're going to have joint legal, but I get to be the tiebreaker, or we split legal custody. So one parent is going to be making all the educational decisions. You can give the other parent a timeline for weighing in. If it's a situation where you think that a parent will want joint legal. Sometimes people just want joint legal because they want that on paper, but then when it comes time to making the decision, they're just going to be absent. You can give them in the court order a timeline for weighing in. So if you don't hear from them, you get to go ahead. Some parties will agree to just follow the recommendations of medical professionals, educational professionals, or whatever. Put that in your decree that, okay, we have joint legal, but if our kids' doctors say something is best, we're going to follow that advice. That can help get rid of some arguments. Or you can decide in advance, okay, even though we have joint physical, for example, mom has primary residence for purposes of school enrollment, it gets rid of that argument about where the kids are going to be enrolled in school. And regardless of custody labels, each parent has what's called Appendix A rights. It's the form attached to each and every order setting custody, and it includes that each parent has the right to important records about the children, the right to attend school conferences, things like that. So even if a parent doesn't have that custody label, they still have very important rights regarding their child. Amy, there's a note here that says, don't trade assets. Did you want to weigh in on that? Okay.
Sure. So in very violent domestic violence cases, or even not violent ones, where victims have fled, they want to have nothing to do with the ex-partner. They want nothing to do with anything. They just want to be done, get out of here. I want to be divorced. This has to get over. I can't deal with it anymore. They, in mediations or other FENEs, SENEs, they will, I have had clients agree to walk away from everything. Their house, their vehicles, their property, their rights to 401ks or retirement assets, their rights to other assets, in order to have sole physical and sole legal custody of the children, because they're concerned for the safety of the children of the safety. That's not right. I think it's the safety of the children. Pardon me. And so when we do asset division, that final judgment, the divorce decree with that judgment, that property division is done. You can't go back and fix that. You can't go back and ask for more money. You can't change it. It is done. But within 1 year, the other party can come back and say, I want sole custody or joint custody, and now I want parenting time, because that can be modified through these processes that we're talking about. So some clients are just really anxious. They're just dead set on that they're going to get the children, and all he cares about is money and not paying child support. And so I'm just going to agree to everything. He can have everything. I don't want child support. I just want my kids. Really, really talk with clients about that huge risk, because they now have lost everything except their kids, which they could lose in the future. So do not trade assets for custody. Couple things I also wanted to mention, and I can maybe wait till we get to the question slide unless we're there.
I think I have one more slide in this section. This one will be quick though.
Is it this one?
Yeah, yep.
Okay.
So this, again, this is a quick one. It's just, I guess, more a reminder, just pointing out to advocates that another option for your clients to get back into court, if they want to, if they're finding that shortly after their order, things aren't working out, either the other parent's not following the parenting schedule or they're not paying child support, tell them to check their order, because attached to it should be this form to request a 6-month review hearing. So if it's right away that it's not working out, it's a super easy form to fill out, no requirements like a motion, they can easily do it themselves. They just fill it out and then it gets them back into court quick, and the court, it's not a chance for the court to change things, but they can review if the child support is current, and they can review if the parties are complying with the parenting time ordered. So basically, if your client is not getting child support, or just the other parent's just not doing what they're supposed to do in terms of parenting time, this will be an opportunity for the judge to yell at that other party, which can be, I think, very helpful. Very helpful upfront, and it's a very easy way for your client to get back to court early. Okay. I think the next one's the question slide.
So are there any other questions on that? Maybe while you type them in, I'll just talk about a couple things that I wanted to go over that I didn't. So when we were talking about the OFP and establishing custody in there, if the other party does request custody or parenting time, there's no basis to grant custody through an OFP. It's only to grant parenting time. I have had judges do it and not be willing to undo it, and the client not be able to appeal. It is not a permanent order though. When the order expires, the custody expires, unless there's been a prior order in a custody or divorce case. When looking at an OFP and parenting time, it's really important to remember that the court is not required to look at the best interest of the children. The court is required to look at the safety of the victim, the petitioner in the OFP, and the safety of the children. So even if going to the other parent might not be harmful for the children, if it is dangerous for mom to do an exchange and there's no other way to do an exchange than a face-to-face, parenting time can be denied. What the court has to look at is the safety of the victim. So remembering that as we're making those arguments about parenting time in an OFP, after the court's made a finding of domestic abuse and is going to issue the protective order, when we're asking for those other parts, remembering that it's not based on the best interest of the child, but based on the safety of the victim. Also, we were talking about parenting time label versus custody labels. So in the 101, we talk about what physical and legal custody mean. So in our cases where we're representing primarily DV and SV victims, having sole legal may be important. If they're in an uneven relationship where there's power over them by the perpetrator, having joint legal isn't really joint legal, because this person's still going to impose the same abuses and force and pressure on the victim that they have been. And so in circumstances like that, there is a presumption, a rebuttable presumption, that when there's a history of domestic violence, legal custody will be given solely to one parent. The Supreme Court has come down in the last year or two saying that that does not necessarily mean the victim will be the person getting the sole legal custody, but simply that it's not appropriate for these two to work together to try to make a decision. If the parties believe they are in agreement about those three major things, education, religion, and medical care, they might still say we're going to do that, but we're not going to have to deal with each other for anything else. We know that perpetrators are sneaky and slippery and can be real charming while we're negotiating, and then later suddenly veto things that the victim thought we had agreed to initially. We're going to stay in this county so that the kids can go to this school district. Suddenly, other party moves somewhere far away and demands kids go there, we have joint legal custody. Either parent can enroll the child in school, they enroll the child in their new county. Suddenly we have an issue. So that legal custody is a pretty important label, and talking with our clients about what that means and how it can be difficult if there's a power imbalance, but also that they have that right to share that. If some people don't want sole legal custody, I don't want to be the only one making decisions for my kids. That's a lot of pressure. Like, their other parents should be involved, and that's okay. But physical custody is a thing. We still have it in our statute, or I don't know why. A lot of times perpetrators will fight and fight and fight. You're not taking custody of my kid. There's no way I'm giving up custody of my child to my person who I think is a bad person, and I like to victimize them. And so I'm going to fight tooth and nail. We're not reaching any kind of agreement unless I have at least joint physical custody. Okay, done. Because I don't care about that custody label. I care about the parenting time division. You can have joint physical custody. That does not mean a 50-50 parenting time split.
Right.
That means parenting time as arranged between the parties and ordered. So it can be you get 0 times a day ever, and you have joint physical custody. So encouraging our clients not to get hung up on that, but to really focus on the parenting time schedule and to make that as concrete and clear as possible, because when it's not black and white, we know that people can weasel around it or do things that, if we don't have an enforceable order, can be detrimental to them and the kids. The other thing I wanted to talk about is agreements. Beth talked about reaching an agreement in the last slide. And just, I always encourage people to, you can agree to an agreement, but don't sign it and do not finalize it that day. Wait at least overnight until you've had time to step away from the situation. They may feel pressured in the mediation. They may feel pressured by their attorney, by the mediator, by the other party, by the other party's attorney. They might just be in such a high state of anxiety or PTSD that they have to get out of there, and they'll agree to stuff even though it's not really what they want. They need to step back from that situation and that experience and look at this paper, and is this something I really can live with, before you sign it. Because of the dynamics of domestic abuse. In regular divorces, that might not be as important. You might already kind of know you're gonna like work together to figure this out. But when there's domestic violence, I always encourage clients to not sign it the day of the agreement, to say, I will look at it tomorrow and get back to you with my final answer. Were there any questions?
Yeah, we had just a comment that came in. Amy asking if you could repeat the first thing you had talked about the things that could not be changed.
Beth, was that you? I'm not sure what we're referring to.
It said, what was the first thing Ms. Isenor just talked about that could not be changed? I guess I'm not, maybe the person who asked that question could clarify a little bit.
Was it about the don't trade assets maybe? When you establish the division of property, that's a final order, and you can't, after your divorce is done and you've got your divorce decree, you can't go back and try to say, oh, I need that car back. The kids, I really need it for transportation for the kids. You're not getting that car. It's the other person's car now. That is a final judgment, unless they agree to give it to you out of the goodness of their heart. Children can be changed. Custody can be changed. Parenting time can be changed. So don't trade something that can be changed, because it's so important. Making sure your kids are safe is so important that victims will give up the property, and it's the property part that cannot be changed. Is
Right.
that answering the question?
Yeah, it looks like that did answer the question. Thanks, Amy. There's also another question that came in. The question is, if there's an OFP in place prior to divorce that states that dad has no contact with children and custody is determined in divorce decree that dad gets 50-50, given the OFP is still current, would the OFP supersede the custody in the decree?
Go ahead, Beth.
No, I was going to say other way around, actually. If you have the order for protection first and then the parties kind of transition into a family court case, you will see that the family court case is given that ability to, what am I looking for? Modify the terms of the OFP, I guess, in a way. So if dad is granted joint custody, parenting time, whatever it may be in the divorce decree, that is what will govern the parties then.
It's the later order.
Yeah. Okay, hopefully that covered it.
Yeah.
Okay. Okay. Okay, our next section is me again. And it's this is the section where we said we are going to dive into whether a non-parent can have custody of a child. I'll try and go through this one a little more quickly because I'm thinking we could do this one a little more quickly. But basically, this is the first thing we wanted to make sure that advocates were aware of, if you aren't already, is a document called a Delegation of Parental Authority. You might hear it referred to as a DOPA for short. And basically, a DOPA can be a really helpful document if you're working with someone who either needs to grant or receive the care of a child for just a temporary period of time, right? So if you're working with a client who's going through a really tough time, can't be the one to bring their child to the doctor, enroll them in school, provide care for them in their home, but they don't want to give up custody permanently, this is a good document. Or on the other hand, if you're working with a client who maybe is like a grandparent who wants to have that authority for a short period of time because maybe they're worried about a child who's going through a tough time and can't make those decisions for their grandchild, they can look at this DOPA, again, Delegation of Parental Authority. We have a little link to the form here. The benefit is that it's a really easy form to fill out. It's just about 2 pages. You're just filling out the child's name, who's going to be getting the authority to take care of the child and who's giving it. It doesn't have to be filed with the court. It just has to be signed and notarized by the person giving the care and the person receiving the care. And it doesn't even have to be provided to the other parent. Like, let's say it's a mom signing a DOPA for her mom, the grandma, to just take care of their child for a little bit. You do not have to give a copy to the father of that child if that father has no parenting time or supervised parenting time or an order for protections in effect. And basically, it's just a document that, again, kind of gives them authority to have them take care of them in their house and can be presented to schools, medical professionals if needed. Some things to keep in mind is it's not permanent. It's good for up to a year, and the person who's giving that authority for the child can make it a shorter period of time. They can put an end date in there that's even before the 1 year is up. And the person who's giving that authority to take care of the child can revoke it at any time. So it's a give and take. It can be good if you're the one giving the authority and you want an easy way to take it back. But if you're kind of depending on this to care for a child, just know that it can be revoked at any time. All right, ready? Okay. And then when it comes to care of or getting custody of a child who's not your own, if you are working with a client who wants to pursue an actual court order, so not just a DOPA, that's just going to be a temporary, really easy piece of paper, but an actual permanent court order, they would be pursuing what's called third-party custody. So like with all other custody and divorce forms, there are easy forms available online. We have a third-party custody packet. And so you could be working either with someone who wants custody of a child who's not their own, or you could be working with a client who's maybe subject to this, is the respondent in a case like this if they find themselves going through a hard time and somebody's trying to get custody of their child. So just really briefly, there's 2 ways that someone can qualify to file for third-party custody. You have to show either that you're a de facto custodian, and under the law, that would mean that you can show that you've been the primary caretaker of a child and that the parent has not been present and they've had a lack of demonstrated consistent participation. So basically that this child's been in their home, living with them, and their parents are absent, or even if they're in the picture, maybe they're just in and out really briefly. And to qualify, you have to look back for the past 24 months, and you have to show the standard for 6 months or more if the child is under 3, or for a year or more if the child is 3 or over. And that time period, the 6 months and the year, it doesn't have to be consecutive. It just has to, you have to meet that standard looking back 24 months. For parties who don't qualify as a de facto custodian, they just can't meet that timing standard or whatever it may be, they would have to show the court that they are what's called an interested third party. And basically that's just saying, I don't meet the timing requirements for a de facto custodian, but the parent of this child has abandoned them, or there's some kind of physical or emotional danger, or there's some kind of extraordinary circumstances. There's something really extraordinary going on here that I need custody. For both, if you're alleging that you're a de facto custodian or an interested third party, you also have to show that you having custody is in the best interest of the child. Through this third party custody process, the court, can grant custody to a third party, and in doing so, it can also give child support to that custodian, so making the parent pay child support to the third party taking custody of their child. And it can also grant parenting time to the parents. So, okay, the court's taking custody away from them, but giving them a parenting time schedule so they can still be in their child's lives, because it is not terminating their rights. They are still very much parent. It's just that they would not have custody if this is successful. And like the custody modification process that I went through briefly, the third party custody is the same way. It's a 2-step process. The court has to see if just the petition has alleged enough to meet one of these standards, and if so, set it for an evidentiary hearing. Just like custody modification, it is not as easy as just a 2-step process. It's going to be a long court process. There could be guardians, there could be custody evaluations, but I think when you're in a third party custody process, it's very likely going to be a long court process. Okay. Anyone have questions about just that short section, the DOPAs or the third party custody? Doesn't look like it, Amy.
I'm not a Star Wars fan, but I love me some Yoda. And there's that seagull song. Never mind. Different YouTube thing, but it's hilarious. Okay, so single moms, we have so much stuff going on because of COVID and just in general, where parents are taking, non-custodial parents, particularly, especially dads, in a single mother child. So the parents are not married. Mom has full physical and legal custody. Mom agrees to allow dad to have parenting time, has the kid go over there. Dad doesn't return child to mom, to custodial parents. Or oftentimes, even if there is an order, not returning the child. So we have a lot of issues with law enforcement and courts even sometimes enforcing that, county attorneys. And so we're going to talk through some of the issues that we're seeing and some hopefully resolutions we can bring. I know there is stuff in the works post-COVID and other issues that are being addressed first right now that we will be training law enforcement about this. But that's going to be in the future. So for now, we're training y'all so that you can help advocate for your clients with law enforcement. So Minnesota Statute 257.541, I've provided the statutes here for you so that it's easy for you to pull back up. The biological mother of a child born to the mother who was not married to the father at the time of the birth or conception has sole legal and sole physical custody until a court says otherwise. So oftentimes law enforcement will say, I don't know who has custody. You don't have any court order. You don't have any paper telling me who has custody. The statute says who has custody. It's right there. Read the statute. But they'll then say it's a civil matter. One, I'm not figuring out who has custody. And two, this is a civil matter. I'm law enforcement. We enforce crime. We address crime and safety. So we're working on training them that this is a crime, and we'll get to the crime step in a second. So when mom has sole physical and legal custody as a single mother, never married under this statute, she can allow the other party to have parenting time. It is solely at her discretion. She is not required to. She's not violating anything by not. She's not withholding the child. She's not violating anything. But oftentimes we want both parents to be involved in our children's lives. And so she can voluntarily allow the other parent to have whatever kind of parenting time that that person wants, and that they agree to, and it just whatever they think is safe for their child is fine. But if you do that, the child is then not integrated, but there's an assumption that this person has a relationship with the child, and when they do come to court and look at the best interest factors, they're going to be able to demonstrate some of that they've been involved in. So it's a good thing for kids. We want it. But if you are in a very violent relationship and you are only allowing it out of fear and you don't want it to be a long-term thing, you might be harming that case by allowing it in the interim. Just a thing to consider. So we cut a question oftentimes, can I move out of state? Can I take my child and go? I'm the sole parent. Nobody else has custody. They're not involved. I don't want them involved. I'm moving to Texas. Okay, so can I do that? Yes, you can do that, but don't do it. Or call a competent family law attorney and we will talk you through it. So if the other parent has any parenting time, according to an order, the custodial parent cannot move out of the state without permission of the other parent or the court. There's no restriction right now on moving within the state. If you want to move to a different city, county, wherever, you can move all the where you want within Minnesota, which is silly because if you live in the Twin Cities, crossing the river is Wisconsin, which is real close to St. Paul, to Hastings, but you can move from there to International Falls, which is like 8 years away, but you can't move across the river, which is 10 minutes away. So it's a silly statute, but even to go to Wisconsin, I had a client who had to leave due to domestic violence, moved in with her parents across the river, worked in Stillwater, had the child in Stillwater, spent their time in Stillwater. Parenting time didn't change with the other party. Nothing was different, except that they physically lived across the river. And the judge was livid that mom had violated the order and left the state without permission. Bizarre, but true. So always, always, always have your clients talk to a competent family law attorney before they move. If you get permission from the other party, document it. Have it in a text, in an email, in writing, something that they've signed, so they don't later change their mind and then say that you're attempting to alienate them or withhold the child from them or something. If they don't have any court order or anything giving them parenting time, it's not illegal. You're not violating any statutes. You can leave, but Minnesota will continue to have jurisdiction over that child for 6 months until you've been in a new state for 6 months, and then that state would have jurisdiction over the child. So if you have been in Texas for 5.5 months and the other parent decides to file for custody and parenting time in Minnesota, Minnesota has jurisdiction over your child. They can require the child to return to Minnesota. They can require the child to be placed with the parent in Minnesota. They can require you to move back to Minnesota. And so knowing the risks of doing so prior to making that decision, which can also be real expensive, is a big consideration. I had a caller just recently who, due to COVID, was losing their job, but had an opportunity. Their job was willing to transfer them and paid for the move, paid for the house, paid for everything. And dad had not had any involvement in the children's life for 3 years. These are like 10 and 13-year-olds. Moved to Arizona, didn't tell dad because dad didn't care before. Why is he suddenly going to care now? Dad finds out they're in Arizona, files immediately. Kids have to return and live with him, who they haven't seen for 3 years, with his new wife and her children. bizarre results, but things that we can advise clients about so that they understand the risks they're taking so that they can make a fully informed decision. If you have an order and you want to ask the court to modify that order or give you permission to move, there is a statute, 518.175 sub 3, that talks about what the court has to consider in determining whether the parent can move out of the state or not. And the burden is on the parent who wants to move to prove that it's in the best interest of the child. It's not the burden on the parent that's staying to show that it's not in the best interest of the child to move. Unless there's been domestic violence, and that's supposed to play a key role in allowing the parent to go to a safe place. So the things that the judge is going to look at is, what's the child's relationship like with both parents? What is the child's age and what impact will that have on them? Is it feasible to have a relationship with both parents if the child moves? Are the parents financially able to fly the child back and forth regularly so the child can see both parents? Is the person willing to drive or meet halfway so the other parent can see the children? Is the child old enough to have an opinion? And if so, what is it? Do they want to leave their school and neighborhood and friends and sports team and church and whatever they're involved in? Or do they want to go to Arizona because it's warm there and it's cold in Minnesota? Does the parent who wants to move have a habit or history of withholding the child or discouraging a relationship between them? Are they moving for the purpose of destroying this relationship with the other party? That's going to be a huge factor. Will the move enhance the child's quality of life? Are you moving to go to school to get a better education so you can provide for your kids and the school you got into is out of state? Are you moving because you got a great job opportunity or your new partner got a great job opportunity, and doing so is going to provide more financial ability, maybe your parents are in the other state and it provides more social support and emotional support and care for the child? And has there been domestic abuse? If there has been, all of those factors are going to go into the consideration that the judge is going to look at before authorizing or not authorizing the child to move. So even if there's no parenting time order, be very careful. You have to be real strategic about making this decision, because they might file to bring you back. And if it's within 6 months, they can do that. If you do it and the other parent had been exercising parenting time or actively involved in the child's life, even if there's not court-ordered parenting time, the judge is not going to like that and is going to look on that poorly when the other party says, they did this to me. The judge isn't going to be happy that the parent moved. It's not illegal, not a crime, but you don't want the judge mad at you in a custody case starting out because you moved. If the move is international, the parent that took the child has fled the country. The Hague Convention is the Hague Abduction Convention is what applies. It's an international law that requires jurisdiction to be where the child has been. We had 2 cases on it in new laws this year. If you want to go back and look at that, there was 1 case in Canada and 1 case in Japan where the court required the children to return to Minnesota in both cases. I want to talk about that more, but we are running out of time, so I'm going to hop right onto this. How do I get my kid back? I don't know. I brainstorm with y'all all the time. I have ideas, I have thoughts, I have statutes, I have case law, I have all kind of stuff that says that you get the kid back. But in a practical sense, how do we enforce that? We don't have a clear answer to that yet, and we really are working hard to figure this out. But just some ideas, some statutes that you can point out to law enforcement or to judges in your community, county attorneys, city attorneys, whoever will listen, because there are statutes that protect kids and get them back to the parent. So if the other party won't return the child, call law enforcement, ask them to help. they won't help, talk to them about the statutes. 257 gives sole custody to single mothers. Dad has no custody. He doesn't get to take my kid. It is kidnapping as if it was a stranger. He has no rights. Deprivation of parental rights, same thing. If you don't have court-ordered parenting time, or you do and you're violating it, it is a crime. It is a felony crime. We see it disproportionately applied to women. Typically, moms are the ones charged with this crime, not dad. But it is a crime. We've had even up to like 17 hours. People have been convicted and gone to prison for depriving a person of parental rights in violation of a court order. State v. Culver is one of those examples. Mom deprived dad of parenting time, just wasn't following the order, and went to jail for it. Like, you got to give your kid to the other parent. You don't get to just be like, nope, I'm taking my kid where I want, if there's a court order giving them parenting time. And again, the International Parental Kidnapping Crime Act is a United States code, which we don't see often, and we're certainly not going to advise you on it. We're not federal attorneys, but we can help connect you with the FBI or other places that can address this if we have victims who are having this issue arise and we need to deal with it. We know repeatedly that law enforcement is going to say this is a civil issue and you need a court order. Continue to call. If you have a client who's struggling with that, you can call on their behalf. If you have a relationship with your community law enforcement, go up the chain of command. They may even tell you that our legal counsel, which is the city attorney for police, the county attorney for sheriff's department, is telling us this is a civil issue. We're not going to address it. Okay, then as advocates in our multidisciplinary teams we're on, as we're working on developing those relationships with our systems partners, we can show them these statutes, show them these case law, tell them that victims of domestic violence are losing their children and their children are in harm, and there's no way for them to get them back if law enforcement won't support them in that, and that these statutes in this case can be helpful in doing that. Document all the efforts, including the responses from the other party. Continue to reach out to the other party, demanding the child back, telling them they're in violation of an order. Do this by text, email, or in writing somehow so that you have documentation of their response to use in court. They'll often say, I don't care what the court order says, I want my kid, or I don't have to give you the kid. Whatever they say is admissions that can be used either in court when you're addressing the deprivation of parental rights, which can be a basis to flip custody or change parenting time, can be a basis for a crime, can be a basis for a lot of things, and so having that documentation can be really important. There is a thing called a declaratory judgment. We have heard of one attorney and some counties that have done this because law enforcement says you don't have an order. How do I know you're the sole custodian when there's no court order in place and the mom's the sole custodian? It's called a declaratory judgment. It's a way to file a document with the court saying the statute says this, I'm the mother, he's not got any parenting time or custody established. I want you to sign this document saying that I have sole custody and that he has no parenting time. A declaratory judgment just is a piece of paper signed by a judge saying this is what it is. Some judges will refuse to sign it. Why are you filing a motion asking me to sign a paper saying what you already have? Why are you asking for sole custody? You have sole custody. Read the statute. Because law enforcement won't read the statute, so can you put it in writing so law enforcement will read the paper because they say I need an order? We haven't done it. I'm not sure I recommend it. I don't love it as an option, but if it's the only way to get kids back, we do what we got to do for our clients, and we do have a sample form attached in the Dropbox. Is that right, Beth?
Not a sample form for the declaratory judgment. I think for that, they're just going to have to contact an attorney. We have a sample form for a passport issue.
Okay.
Yeah.
Okay. Thank you. I flipped that in my head.
Right.
And as always, this is why we encourage you to have those strong relationships with your systems partners, law enforcement, prosecution, attorneys in the community who can help you with these kind of things when they come up. We are at 3:30. We are technically out of time. Anyone who needs to leave is free to do so. We're going to finish up the last couple slides and keep it recorded for our YouTube channel. But thank you for all of you who have to leave for participating and being here.
Thank you.
Also, ideas to move through. If the other parent won't return the child, how can we as advocacy help our clients figure out a way to get the kid? So is the child in daycare? Go pick up your kid in daycare, even if the other party says you can't. Is your child in school? Go pick up your kid from school and get them home, even if the other child says you can't. Do you have trusted mutual friends or family members who will intervene or intercede, or go pick your kid up? Maybe grandma, dad's mom is allied with you and knows that dad's a bad guy, but still has a relationship with her son and sees your child. Have her bring your child home to you. Moms have a right to go to the house and pick up their child. Whether the other party will allow that is always an issue, but we just need to do safety planning with them so that if they choose to do that, they're doing it in a way that's safe for them and the child and doesn't create more violence. Is there enough of a safety concern at the other parent's house that child protection will become involved? As always, we caution you about encouraging child protection to get involved with our clients. But if the child's not safe at the other parent's house and that's what you need to do, again, we do what we need to do to protect kids and our clients. Is there a basis for an order for protection? You can petition on behalf of the child and ask the judge to recognize in that order that the victim, the petitioner, has sole custody, and that you can ask the judge to specifically order that law enforcement intervene, that law enforcement engage in actively returning the child to the victim parent, and that they're ordered to enforce this order. You can also do that in a declaratory judgment, which is one of the reasons some counties are moving towards that. You can file an emergency motion or request for an expedited hearing if you have a current, if you've already established custody in a divorce or custody case. Take care in filing a custody motion if one does not already exist. If one exists and custody and parenting time is established, file your emergency in there. If it doesn't exist, we don't encourage filing it. You have everything. Don't get a judge to take away what you already have and give some to the other parent. So we discourage that whenever possible, but always talk with an attorney about that if it has to happen. Questions on getting kids back? The answer is, I don't know. And we are here to support you and continue to talk through it with you. Call us.
It looks like we did have a comment. It says, if you're pregnant in fear for your life, then it's okay. And it says, looks like they're thinking the question had been answered by the 6-month answer from you, but
so if you're pregnant, you can go anywhere you want.
Right.
No one has jurisdiction until the child's born. And whatever state the child's been in the longest, if they're less than 6 months old, is where the jurisdiction exists, not where she became pregnant.
Right.
So yes, she can leave. Do so before the child's born. No.
Okay. And just the one thing I would add before we just finish up with passports is that for the order for protection, this may not work in every county, but when I was partnering with Dask in Hennepin County, it was not uncommon for, even if you're not going to bring an order for protection on behalf of the child that let's say the dad's taken, but let's say your parting was very violent, they ended up with the child and won't let you have the child back. Even if the order for protection is just for you as petitioner or just for your client as petitioner, you can still petition for that relief and at least put the request in there. I'm petitioning for myself, plus, Judge, will you please use this order to recognize that I have sole custody and ask for immediate return? So it's not, if not only on behalf, exactly. So not only on behalf of the other child, on behalf of the child, but even if it's on behalf of the petitioner, still ask for it. I do see judges grant that.
Absolutely. Good point.
Okay, so just quickly finishing up with passports, just kind of a common question we get to is, can I apply for a passport for my child? A lot of people want to travel out of the country with their child. So just a note that if your child is Under 16, their passports are only valid for 5 years and they can't be renewed. You have to reapply. And it's very strict. It's governed by the U.S. Department of State, and it's very strict that both parents have to be present to apply unless you can do one of a few things. One is demonstrate sole legal authority. So like a court order, that'd be a really good reason for a client to push for sole legal custody if they know that this is going to be an issue and that dad's not going to cooperate in signing for a passport. If they have sole legal custody, they should be able to apply. It can also be if they have something like they're the sole parent on the birth certificate. They can have, if they're in a situation where the other parent doesn't want to come with them, but they'll maybe at one point agree, you can have them sign and notarize a statement of consent. Or in really tough circumstances where you absolutely can't find the other parent, there is a form for the U.S. Department of State where you can demonstrate, they call it exigent or special family circumstances, that the other parent can't be found. I will say in practice, I feel like this is very rarely granted, but it is out there. Okay. And the next slide, I think it's our last one. We just wanted advocates to be aware that some counties do have a process in place for, it would be specifically for single mothers. So those single mothers who have sole custody under the statute, but they have nothing to show the passport department, they do have a process in place for them to apply for an order just to get a court order to apply for a passport. The counties that we're aware of that have this process are Dakota, Hennepin, and Scott County. And part of the paperwork that we included in the Dropbox is the sample paperwork from Scott County for, it would be in that case a single mother to apply for permission to get a court order to apply for a passport. So what we would suggest is that if you're in a different county than these three, take the paperwork, cross it out, make it applicable to your county, write in the name, write in the whatever district it's in, and submit it. Try, make an attempt. It's a way to at least try to get it out there and have your client get that permission to apply for a passport for their child. If they're in Dakota or Hennepin, or if you want to check to see if your county has that procedure, you can refer clients to the statewide self-help center. We have the number there, and the statewide self-help is a really great resource. They can answer questions about paperwork that's available and refer your clients to their appropriate county. Okay, I think that's it.
This is the end of our presentation. Any questions? So I apologize for going over. We're almost 10 minutes over here. As always, we want to include our direct lines and direct emails so you can contact us with any questions about family law. As always, call Standpoint. We are here for you. This is our job. It's why we exist, to support advocacy throughout the state of Minnesota as you support victims of domestic and sexual violence. Thank you so much for all the work you do for our victims and survivors, and we are here to support you. Call me.
Thanks, everyone.
Thank you, Amy and Beth, for presenting today. Thanks, everyone, for coming out. And the link for our YouTube, it will be emailed out to the listserv. So if you want to check it out again or rewatch some things, and they also referenced our other webinars, which are on YouTube as well. So thanks, everyone, for coming out. If there are no further questions, I will end the webinar.
Thanks, everybody. Bye.
Thanks, everyone. Thanks, Jay.